for president. In these local elections, there was no line. I was number 300.
Wow.
Oh yeah, local elections, are it's disturbing, but it's not surprising. It's one of the reasons why I keep focusing. I keep telling people, pay attention to the local. Local is where you're going to get your most protection. It's also where you have the most influence because so few people paying attention to it. So let's see, the live stream's up. So we'll see if we get people joining today. I always wonder.
I have no trust on YouTube. I'm just throwing that out there.
Oh, neither do I.
Absolutely no trust.
My numbers in YouTube have been tanking. My every morning I check my the stats, the analytics, and my number of viewers, my hours watched. They're a third of what they were 6 months ago, even 3 months ago. And I'm like, I'm putting out the same content, the same way, to the same place, but people, YouTube doesn't want people to hear it. So
I'm paying attention to Rumble. No censorship there.
I put everything on Rumble too. I'm not getting a lot of traction in Rumble. I'm only getting a few views a month on Rumble, and I haven't figured out how to get that share, that going more. Well,
most of your videos that are on Rumble, I view through the Constitution Scholars website. So I don't know if that's attributing to the views or not.
Because I don't host my videos through, I don't host them through YouTube anymore. I could host them on my own platform, but right now I'm doing Rumble. And so if you watch it through the Constitution study, then that you're actually watching through Rumble. So it gets the count, but that's probably most of what I'm seeing. So who knows? And yes, Florida Man, it's big tech censorship. It's actually, I don't even refer to it. I don't even know if I want to refer to it as big tech censorship. It truly is. It's Marxist. It's the anti-liberty. It's 1984. It's Brave New World. It's the classic dystopian. You censor the views you don't want people to hear. And if most people get their information from one source and you censor that source, they don't know the truth. That's why I distinguish between ignorance, foolishness, and stupidity. Ignorance is a lack of knowledge that's easily solved. Foolishness is ignorance paired with naivete. In other words, you're ignorant and you don't know you're ignorant, and so and then stupid is, well, that's ignorance and arrogance. And my other favorite line is, it takes a lot of education to be that stupid. So, okay. Hey, we're at the top of the hour. Out there in YouTube and Periscope land and a little disheveled. I got a little bit of a late start getting things set up, but we're here. We're at the Constitution study. We're at the live Q&A. We've got some people in the Zoom. It looks like I got maybe one or two people on the live streams. It looks like I got somebody on YouTube. I don't trust the numbers that YouTube gives me, but we're here. We're here to ask questions. We were chatting a little bit about what's been going on with critical race theory and the schools and censorship. And you're right, Florida Man. Most people don't care about the Constitution, mainly I think because of the way it's been taught. Because I'm a product of public school, right? I went through 12 years of government-run school. To me, the Constitution was, 1776, Declaration of Independence, Independence Day, day off. Beyond that, it was for lawyers and judges, because they told me the only people that could understand it were lawyers and judges. You had to go to school. The Supreme Court were the only people smart enough to know what it says. And then I got introduced to a guy that taught history in a way that didn't put me to sleep. And I heard about this guy by the name of John Jay, who said, every member of the state ought diligently to read and study the Constitution of their country and teach the rising generation to be free. I took that as a challenge. I read it. And that's when I got interested in the Constitution. when I realized not only what I hadn't been taught, but how much of what I've been taught was wrong, was a lie. That's where you get to, there's a lot of ignorance where, the people are taught that the Constitution is hard to read. They're taught that it's complicated. They're taught that you need, 6 years of school to understand it. And they never find out for themselves, which, by the way, is part of the reason why I'm traveling. I'm going around this summer to see people, to teach them that they can know their rights. It's not hard to read the Constitution. That, when you do actually know what your rights, not only do you care what the Constitution says, but you're able to defend yourself against some of this nonsense, some of this craziness. So there's my first plug of the night for the Knowing Your Rights tour. If you want to find out more, constitutionstudy.com/tour. You can find, there's not only information about the tour, there are dates, there are locations. There's even a form to ask that I come speak at your group. So if you want to add a stop, doesn't need to be big, doesn't need to be complicated. We're meeting in the back of a bakery in one town. If we can meet in a back, you find a restaurant with a back room, you find a shop with a back room, you just find a spot and we can sit and talk. We'll see if we can make that happen. There's more there. I don't really have a specific topic to talk about. We are approaching Independence Day. And I gave myself a little project for Independence Day. So maybe I'll tease you with that. Now, we all know that Independence Day is the day that two people signed the Declaration of Independence. Declaration of Independence has a rather interesting history. It actually started on June 7th, 1776. A guy by the name of Richard Henry Lee said, hey, this is enough. We've had enough. We've tried enough. We should declare independence. The Lee Resolution, that we declare independence from Great Britain, had three parts: declare independence from Great Britain, form foreign alliances, and determine how the new states could confederate together. Being good politicians, pretty much everyone in that room, after they changed their underwear, said, all right, tell you what, we need to go back and talk to our colonies and figure out what we're going to do here. In the meantime, we'll pick 5 guys and they'll go out and they can draft this declaration. Talk about, Richard. Come on, we'll give it a shot. Thomas Jefferson, Benjamin Franklin, John Adams, Richard Sherman, and I always draw a blank at the last guy. Can't think of his name. So they go off and they start drafting the Constitution. Of course, Jefferson was the primary author. He wrote most of the stuff. They come back July 2nd. They go, yes, we're going to adopt the first part of the Lee Resolution. We are going to declare independence. Now, Jefferson, what you got? Interesting enough, John Adams wrote that to his wife that evening and said that the country would celebrate July 2nd with firearms and parties because we actually declared independence on July 2nd. They take the Declaration of Independence, they do a little massaging, they tweak a little bit. July 4th, they all agree to it. Only 2 people signed it. John Hancock, because he was president of the Congress at the time, and I forget, it was a secretary, I forget who the other person was. Most people didn't sign it until August. But the day that they actually agreed to the language of the Declaration of Independence was July 4th. What does that have to do with my little project? Well, I sat down and I reread the Declaration of Independence. And as I was looking at it, I'm like, an awful lot of what they're talking about here really applies today. So I actually sat down and I wrote what I call the Redeclaration of Independence. I took the Declaration of Independence. I changed surprisingly few words. And on the 4th of July, there'll be 2 posts that are going up to the study website. One will be a PDF of the Declaration of Independence showing all the changes that I've made. Right? I'm not saying we throw out the government in Washington and we start again. I'm talking about regaining control of the government in Washington. So Independence Day, it's not this Sunday, it's next Sunday, isn't it? Yes, it's next Sunday. Will be a PDF of the Redeclaration of Independence, and I will have my article out with the video, which where I'll be going through the Declaration and making the point. And the point I want to bring up is I'm not talking about insurrection. Right? I know it's going to be called insurrection. It's going to be called a lot of things. But when you look at the Declaration, when you look at the grievances in the Declaration of Independence, the 27 reasons that our founding fathers gave for declaring independence from the King of Great Britain, you'll find that each and every one of them can be applied to some portion of the federal government, if not the entire federal government. I went through all 27 grievances, and each and every one, there was one that I ended up, I had to sort of rewrite it because the language made no sense unless I did the whole paragraph. But for most of it, it's like, take out King George and put in the federal courts or the president or Congress or just the federal government. And it's really disturbing how much of the reasons the founders of this nation gave to declare independence exist today between the people of the states and the federal government. And I'm hoping that people will look at this and then ask their states, why are we doing this? Why are we putting up with this? When do we redeclare that we are free and independent states? We are not subjects of the government in Washington, D.C. So hopefully people here will enjoy that. They'll find it interesting. That's been my little project. So, Florida man, you're here. You know, everybody here knows the drill, right? If you have a question, let's bring them up. Let's get them going. Florida man, type them into the comments. We got someone new joining in. If you're in the Zoom, you can just ask, interrupt, and let her have. You got a question there?
Oh, no, I'm just saying John's here. The whole A team this time, like completely.
Dun, 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 dun. Do we love it when a plan comes together? That's all I want to know. Do we love it when a plan comes together?
Okay, yeah.
See, I'm old enough to have grown up with the original A-Team TV program. I used to watch the original A-Team with Mr. T and the whole 9 yards. So yes. And who was the character that played the crazy pilot? He was my favorite. So
yeah, I got a question. So unless someone else wants to go first, I don't mind.
Hey, no, go. This is
okay.
This is a preview. This is a preview of the Knowing Your Rights tour. Just ask a question.
Okay. So I was curious. So you got the 4th and 5th Amendment, and one says you can't have your property or you can't be deprived of your life. Let me just get it. But I think it essentially means you can't have your property or your rights or any good stuff taken from you without a warrant. Now, I was curious as to how does due process play in with a warrant? Like when they make a warrant, don't they do it kind of behind your back? Wouldn't you have to be in court? I don't know.
Okay. So yeah, in fact, the 4th through 8th Amendments are referred to as the due process amendments. That's their purpose. So you have to understand what due process is. The easiest description, well, let's say the dictionary, Noah Webster, in his dictionary, you have 2 words, right? Due, which means what you're owed, and process, which basically means a procedure that you follow. So due process is a procedure that grants you what you are owed. Okay, what does that mean? The Modern Free Legal Dictionary defines it as a judicial or governmental process designed to protect the rights of the individual. So when you look at due process, it doesn't necessarily mean that you are there. It's does the process protect your rights? So you look at the 4th Amendment, right? You have the right to be secure in your persons, houses, papers, and effects from unreasonable searches and seizures. I want to stop there. The court, starting with the Supreme Court and some of the really twisted decisions, kind of changed this question of searches and seizures or specifically searches to privacy. So the classic example, we've all seen it on some crime drama, right? You take your garbage out to the curb and suddenly the government can search all they want because you have no right to privacy on the street corner. which misses the entire point. It's not a question of whether or not you've kept your stuff private, is when does the government have the authority to search? It must be reasonable. In general scopes, reasonable means one of two things. Either they have gotten a warrant, which means they have come up with probable cause. Someone has come up with probable cause supported by oath or affirmation, meaning they have gone before a judge, put their right hand in the air, their left hand on the Bible, and said, I swear or affirm that the evidence I'm giving is true under penalty of perjury, right? So you have probable cause for oath or affirmation. The warrant must be particularly describe what is to be searched and the persons or things to be seized. Meaning, to protect your rights, government cannot search without either a warrant or what's called an exigent circumstance. Exigent generally means immediate. So, for example, government cannot come into your house without your permission or a warrant or an exigent circumstance. So if a law enforcement officer is in hot pursuit of a felon and the felon comes into your house, law enforcement's allowed to follow them. You can't expect law enforcement to stop at the door to get a warrant to enter your house when they're chasing a felon. It's not reasonable. So that's a reasonable entry into your house. The security of your house is breached for a reasonable purpose. The other example, and again, we've seen it in crime dramas, right? They knock on the door, nobody's home. Do you hear that? Someone's calling for help. They break down the door, right? It's if there's an emergency where someone is in danger, government has the authority to come into your house. So if the cop is walking down the street, I'm old enough to remember beat cops, right? Walking down the street. If they see smoke coming out of the door or smoke coming out of the window, they can enter the premises to see if anyone's there. If they're walking by and they hear somebody yelling, "Help me, help me, help me," they can make entry because there's an urgent, immediate need, an imminent, an appearance of an imminent threat. So your right to due process is protected because the idea is they can't come in simply because they think something's going on. They have to have real cause. Now, here's what's the interesting. There was recently a case. Forget where it was. I actually wrote about an article about it. A gentleman and his wife were arguing. At one point, the guy takes a gun, puts it on the table and tells his wife, just shoot me and get it over with. It'd be easier that way. She leaves, spends the night at a hotel, gets up in the morning. She's concerned about her husband. He may be suicidal. So she calls the police to do what's commonly referred to as a wellness check. Police pick her up. They go to the house. They talk to him. He says, no, we were arguing. I was being loud, but I'm not a threat. I'm not going to kill myself. I'm not going to kill anybody else. They said, well, because she asked for a wellness check, we want to take you to the hospital for an evaluation. He says, okay, only if you agree that you're not going to go into my house and confiscate my guns. They say, no, we're not going to go into the house, confiscate your guns. He goes off, gets his mental health check. Doctor says, yeah, he's fine. He's not a danger. You just, he was having a really bad day and spouted off. Well, meanwhile, the cops, while he's at the hospital getting checked out, the cops lie to his wife, tell his wife that he's given them permission to confiscate his weapons, enter the house, grab his guns, and leave. Now, he goes to pick up his guns a couple days later. They refuse to turn them over. His wife goes to pick up the guns. They refuse to turn them over. Now they went to court. Guess what? The Supreme Court, and I haven't written this part down. It only happened a few days ago. The Supreme Court said, you can't do that. You had no probable cause to search you had no exigent threat. He was no longer there. He was not aggressive when he dealt with you. He was calm. He was reasonable. You had absolutely no basis, no probable cause to enter this man's house and search. You had no exigent circumstance. You did not even try to get a warrant. What I'm waiting for is I'm waiting for this gentleman, now that he's won that suit, is I want him to file a complaint with the U.S. Attorney's Office because those law enforcement officers broke the law. But I know that's not going to happen because nobody thinks that way. I'm weird. The thing with a warrant, the one that actually is a little more interesting is actually the Fifth Amendment, where you have a grand jury. Any what's referred to as a capital or otherwise infamous crime, what we would today call a felony. You cannot be indicted with a felony. You cannot be charged, or I should say, you cannot be tried for a felony offense except on indictment by a grand jury. Now, the purpose of the grand jury is to make sure that the government cannot put you through the financial, the emotional, the legal hurdles of putting on a defense and a case without getting citizens okay. So in other words, Tunnel Lord, if the government said we want to come and we want to charge Tunnel Lord with a felony, before the state can do that, the people have to agree. You get a grand jury, everyday citizens. It's one of those reasons why I say jury duty is so important. They have to go to a jury. It's generally 24 people, and they have to get, I don't know if it's a majority or it's unanimous in a grand jury. I don't know off the top of my head. I think it may vary state by state. But here's the interesting part with the grand jury. The defense doesn't appear before a grand jury. Only the prosecution, only the state appears in the grand jury. So the grand jury only hears one side of the story, which is why they say a good prosecutor can get a grand jury to indict a ham sandwich, because they don't listen to the other side. And the people that are there, I think they approach it as, well, they wouldn't be doing this if there wasn't a good reason, rather than realizing their purpose is to examine their case and say, no, you've really got to have, do you have enough evidence to warrant putting on a trial, putting the defendant through all of this?
Wouldn't you think that that's a violation of habeas corpus if they're proceeding with a grand jury without having you there to rebut whether or not they should even have grounds to press charges?
Well, understand habeas corpus, which is Latin for produce the body. It means that the right of habeas corpus is the right, if you are imprisoned by the state, to be heard by a court. If you're dealing with a grand jury, you are not, unless you are being held in jail pending trial, you don't have a right to, the habeas corpus wouldn't apply, in which case, again, it wouldn't be before the grand jury. You'd be going before a judge going, wait a second, another example. So January 6th, we had the actions of several in the Capitol. And based on some of the video evidence I've seen, many of them committed nothing more serious than trespass. They didn't break anything. They didn't damage anything. They were allowed on the premises, but then they were asked to leave and didn't. They committed trespass. Yet, how many of them are still in jail? How many of them are still being held in solitary confinement? That is where I look at habeas corpus going, wait a second, tell me where that is not an excessive fine or an excessive bail. Tell me what that's not excessive. You're telling me I don't have the opportunity for bail. Now, again, even if those who committed property damage, right, that's a misdemeanor. Again, you're telling me they've been held in, how many people are being held in jail for months for a misdemeanor? That's where habeas corpus comes up, and their lawyers should be filing writs of habeas corpus going, wait a second, produce the body and show us why this person is still in jail for a misdemeanor. That would fit more than simply than a grand jury proceeding. Because remember, a grand jury doesn't convict you. All a grand jury is saying, yeah, we the people think there's sufficient evidence to try you. So that's a good. So Tendler, did I answer your question?
Yeah, I think so.
I know sometimes I get down on these rabbit trails, and like I said, it's one of those things. I find this stuff so interesting.
It's fine. I can watch the recording later and break it down.
So yeah, the idea of a warrant is to make sure that your rights are protected, and the fact that the courts have utterly, for the most part, have failed, and it's generally been because, in my opinion, as being that a court is part of government, they tend to want to side with government. They tend to want to find ways to allow government actors to do what they want more often than not. So that's where we run into. That's where we run into that. Who's next? Yeah,
Just
go
to
ahead.
tack on to that really quick,
Yeah.
I was actually going to ask you about that. It's really not a huge thing, but I did notice in Article 1, Section 9, it does say the privilege of the writ of habeas corpus. It doesn't say right. I thought that
Yes.
was very interesting.
Well, understand that the definition of a right is a just claim of a just claim, immunity, or privilege. So, today we make a distinction between a privilege and a right. That's an imprecise use of the English language, right? The privilege, you have a right to the privilege of habeas corpus, meaning you have the right to the habeas corpus is a positive requirement from the state. It's you have a just privilege to require they produce the body, right? It's what I generally refer to as a positive right. Florida man asks, can I talk about the Supreme Court case dealing with the free speech in Pennsylvania with the cheerleader? I'm aware of it. Right now is silly season. I call it silly season from the Supreme Court. There's lots of cases coming out. I have not dug into the opinion. It really came down to, can the government in the form of a school district punish a student for speech that did not happen on campus? And the court, if memory serves, the court said, no, you cannot punish her for the fact that she used foul language off campus, even though she was talking about the school or some school event. And so I'm not sure why Thomas dissented. Justice Thomas is an interesting character. For the most part, Thomas tends to be pro law enforcement. So I don't know if he's looking at a law enforcement issue behind this, or if he saw something I haven't seen yet, but I haven't actually researched. It's on my stack. I have a whole stack of these cases that I've been going through. And the good news is these will be Monday morning articles, right? I'm not simply going to breeze through most of them. Most of them I'll sit down and try to digest the opinion itself, pull it apart, and give my comments on it. So hang tight there, Florida man. It's a coming. It just isn't here yet. Anyone else? Come on, it's more. Let's see.
So I was watching some videos of cases that lawyers need to study in law school.
Mhm.
And there was one video. I'll have to look through my YouTube feed to see if I can pull it up. But it really pissed me off. So there was a lawyer that was talking about the elastic clause of the Constitution.
The
where
what clause?
The elastic clause, it's the one where it says Congress shall have the power to make all laws necessary and proper to carry into execution foregoing powers.
I've
Now,
never
the
heard that
prob-
referred to the elastic clause. It's always been the necessary and proper clause. So,
Well,
whatever.
That's what he referred to it as, and I've
Okay.
heard it referred to it that way. Anyways, the really irritating thing that I saw while watching this lawyer talk about it was that he would only say Congress has the power to make all laws, and then he'd stop the sentence. He had to have said it, God, at least 25 times, and he would
Mhm.
never finish the sentence. It drove me absolutely batty. And then basically crushed, well, quote unquote, crushed the 10th Amendment by saying that Congress has the power to make all laws. So, I mean, the states, all powers not given to the government are reserved to the states, but the federal government has all power. And I'm like, but you didn't even finish the damn sentence.
But and most likely, again, you're talking about a lawyer, which means he or she went to law school. At law school, most likely he or she did not actually study the Constitution. They regurgitate what they've been told by their professors. So they say, yes, Congress can make all laws necessary and proper. If you follow any of the recent state Second Amendment legislation, the Second Amendment sanctuaries, as they're commonly called, there are several lawyers, several people who really should know better, saying these violate the Supremacy Clause. Same thing. They don't read the whole thing. The Necessary and Proper Clause, which, to quote the whole thing, in case for people who may not know, that Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or office thereof. So yes, Congress can make any law that involves putting into exercise a power delegated to the United States by the Constitution. In other words, that part of the 10th Amendment that says, all powers not delegated to the United States remain with the states, but they're not taught that. It's the same thing with people who, and I'm trying to get to a discussion with one of these people online to say, okay, explain to me how a law that infringes on the right to keep and bear arms is made pursuant to the Constitution. That's the Supremacy Clause, right? Article 6, Clause 2, the Constitution, and the laws of the United States, which shall be made in pursuance thereof. The word pursuance is kind of like process. Due process is not just any process. Pursuance means you are following the document. You're following the spirit of, actually, how did they put it? Let me look it up. Let me look what Noah says. Because you know me, I like Noah. Not the guy that built the ark. I like the guy that built the ark, but let's see, a prosecution process or continued exertion to reach or accomplish something, right? So when you're done in pursuance, you are following the Constitution. You're using a process to accomplish what the Constitution says. If you violate the Constitution, that law cannot be, then that law cannot be supreme. It cannot be made in pursuance. And in fact, find that YouTube video, put into the comment section, has this person read the opinion in Marbury versus Madison? And if you want, check the Constitution study. I did an article on that because let me see if I can, did I save that link? Where did I put that link?
That was actually one of the next points that he made, was something about the Marbury v. Madison case, judicial review, and that the court gave themselves the power to strike down law. And then, of course, I got all bent out of shape about that as well, because the court can't give themselves power, right? That would be legislating from the bench, and all legislative power shall be vested in one, Congress of the United States. So they can't do that. Second off, the idea that Marbury v. Madison established judicial review is absurd anyways. The only thing that Marshall was saying in Marbury v. Madison is that there's two issues here and they're in conflict with each other. Marbury is entitled to his commission because John Adams gave it to him while he had the authority to do so. But this court lacks the power to force the executive branch to deliver that commission. So Marbury's entitled to it, but we don't have any power. Sorry.
Exactly. So the judicial review, again, you're right. The opinion reads, it is emphatically the providence and duty of the judicial department to say what the law is. And that's where most lawyers stop. Read the rest of it. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. So if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that the case conformably to the law, disregard the Constitution, or conformably to the Constitution, disregard the law, the court must determine which of these conflicting rules governs the case. This is the very essence of judicial duty. In other words, you look at the case before you. If the Constitution and the law are in conflict, you have to review both laws, right? Doesn't mean you overthrow, you overrule. It says we review the laws. We look at the laws, what they say, we understand them, and then we apply them. Marshall went on to say, if then the courts are to regard the Constitution and the Constitution is spared to any ordinary act of the legislature, the Constitution and not such ordinary act must govern the case to which they both apply. Right? So you're right. The Marbury versus Madison, the court not even the court said, we have the ability to overrule congressional actions. The court never said that. That is not the opinion of the court. The court says, yes, when we're dealing with a case, we have to review the law. We have to look at what it says. And if there's a conflict between the two, we have to opine based on the Constitution rather than the law. It didn't say the law is, well, let me phrase that. He specifically said this deals with the court before them, because the clause I want you to refer to this person, and he said when you read Marbury versus Madison, thus the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that all courts, as well as other departments, are bound by that instrument. What you're basically saying is, listen, the court can look at it and say, yeah, you know what? That law is void. But that's the extent of the power the court has. The court doesn't make that law invalid. It doesn't eliminate that law. It's amazing the number of federal laws that are still on the books that nobody applies because some court said so.
My understanding of the court saying this law is void, right, is that they have determined in the case before them that this federal law does not hold any relevance in the case before us because it violates the Constitution, and it only pertains to the case before them. This ridiculous decision to follow stare decisis is absolutely ridiculous. When I was watching the confirmation of Kavanaugh, every time I had to look it up, I didn't know what stare decisis was at the time. I was like, I don't know who she is, but I don't like her because it's ridiculous. You take the opinion of past judges, and if they got it wrong, then what? I'm bound to suffer the consequences of a judge who was wrong 200 years ago? Mm-hmm. That's absolutely absurd.
Oh, you're absolutely right. It goes even beyond that. It violates their oath of office because they have placed the opinion of a judge above the Constitution. The Constitution is no longer treated as a supreme law of the land. The stare decisis is a power grab. Now, let me rephrase it. There is a place for stare decisis. If you imagine you're a lawyer, you're a judge, and you get handed a case. One of the things you can do is you can look at hey, you know what? Judge so-and-so had a case almost exactly like this. What did he find? Or, Judge Jane had a case very similar to this. What did they find? And let me short circuit some of this and get their opinions. But that doesn't absolve of the responsibility to the actual law as it is written.
I don't find a problem. I don't find a problem with reviewing past cases to make or to base your opinion, because somebody has already gone through this, and you can look at what the decision somebody else came up with and say, yes, I agree with that. That makes sense. And so in the case before me, they're very similar. So I will agree with the judge in this case, or I totally disagree with him. And if the plaintiffs before me have an issue with my ruling, they can appeal it to a higher court and send it right back to the Supreme Court. And just forcing district courts to follow something that the Supreme Court said 85 years ago. I mean, you're binding us to the opinions of judges of the past.
But
And if they got it wrong, we suffer. We the people suffer for it.
But look, you're right. But look at how this happened. So when I look at stare decisis, to me, it's less a question of do I agree with the previous opinion, is what was that previous opinion based on? I have what's called the INTOT principle, INTOT. I never thought of that. So someone brings me a case and I look at it and I say, well, what did they find? Oh, you know what? I never thought of it that way. Who was I talking to the other day? Andy, it was you. You had asked me a question. In fact, I wrote it down because I do want to cover it in the on the radio program.
I just remembered that.
Where did I put it? I know I have it in here somewhere. I know I saved it. It was something to do with.
It was I'm sorry, I'm trying to recall off the top of my head. It was something with healthcare versus
oh yes,
right to counsel. That was it.
Yes, the positive right to counsel versus the right to healthcare. And what's interesting, and we had this discussion, is Andy asked a question. I had never thought of that. I'd never thought of it from that point of view. So we talked for a couple minutes and we came up with an answer, and it didn't change my long-term opinion. But the very idea that somebody else looked at something from a different point of view and saw something different meant it was worth looking at. So let's take this example. Let's say Andy and I are judges, right? And Andy looked at a case and he looked at it and said, well, if you can compel people to pay taxes to provide for legal counsel, why can't you collect taxes to pay for health care? Therefore, he opined in his case that Obamacare was valid because the government has the right to tax, and if you can compel money if you can compel legal services, you can compel healthcare services. I get a case. I look at Andy's opinion and say, okay, that's an interesting thought, but you missed something. In other words, I don't simply say, well, Andy said it's okay, so it must be okay. What's Andy thought? Oh, you know what? I never thought of healthcare and legal services. Now, for those of you who might be interested, the main difference is when they talk about when the Fifth Amendment right to counsel, the government is out to get you, right? The government has charged you with a crime. The government is imposing its force upon you. Therefore, you have the right to compel the government to make sure you have legal counsel. When you're dealing with healthcare, the government is not imposing an illness on you. That's the difference between the two.
Can I spin on that a little?
Just saying, but stare decisis should work that way. I should look at what Andy came up with and consider his point of view, but still go back to the law and say, yeah, but wait a second, there's a difference here. Go ahead, Sean.
That's exactly how I tell people about how I think stare decisis should work. Not being bound to it, but simply referring to it if necessary.
A head start.
But I don't believe that the right to counsel originally started with government providing you counsel. The right to counsel was the ability to find a lawyer shall not be denied, but not that they would provide it. You were ultimately responsible for your own lawyer. And if you could find one, they could not deny allowing a lawyer to talk on your behalf.
Well, so here's the question. If something is a right, if it is a just claim, immunity, or privilege, who is that claim to counsel against, right? So when we talk about the right to counsel, yes, you have a right to counsel. If you cannot afford counsel, one should be provided for you. It's a claim on government. Yes, not to deny you counsel, not to deny the counsel that you want. If you can't afford counsel, you do not have the ability to compel counsel, right? You can compel witnesses in your favor. You cannot compel counsel. So that's a scenario where I don't have I don't see a constitutional issue. I agree that for the most part, the assumption is, listen, if you can afford it, you don't want a public defender. In general, they are overworked, underpaid. They're trying to clear case counts. They do not, as a general rule, right? I know I'm painting with a broad brush. As a general rule, most people who go into public defender's office really have a heart for the people they're trying to defend, but they are so overworked. You're not going to get the best defense from a public defender, but they will give you information that you may not have thought of because you weren't a lawyer, you didn't go to law school. So when I look at it saying, how far does that just claim go? Is it the privilege, I should say, is it the immunity from being denied counsel? Yes. Is it the privilege to get government to compel counsel if you can't afford it? I think so, although I do kind of see your point as I can see that point of view. I still tend to lean to as a right, things you have a right to. Again, I keep coming down to the word right. It's something you should not be denied simply because you can't afford it. So,
don't get me wrong. I don't have a problem. Morally, I don't really have a problem with providing people a lawyer, even by paying through taxes. And I'm very strict on what I think we should pay taxes on, because that government doesn't fund anything. It's always us,
exactly.
Right? We pay for everything government claims to do. So I'm very strict on taxes. I don't think taxes are wholly bad, but I don't think they're amazingly awesome either.
At best, they're a necessary evil.
But my whole point with the Fifth Amendment was, I can't remember when it was, but it was a Supreme Court case, and I believe it was after Miranda. I don't remember who it was. The one that established Miranda rights.
Mm-hmm.
After that case, there was another case where the Supreme Court ruled that a lawyer will be provided if you can't afford one.
Mm-hmm.
And like I said, I don't really have a problem with that. If it was written into the Constitution, I wouldn't have a problem with that at all. It's just changing things through Supreme Court rulings is a very bad idea.
Yeah, and by the way, the proper term is the Miranda warning, not Miranda rights. That's another Hollywoodism.
I know it's it's. I know it's called the Miranda warnings, but when the police hand you the piece of paper, they say these are your rights. Well,
yes,
and I know for the record, because those aren't my rights. I know what my rights are, and those aren't them. They encompass some of them, but that's not all of my rights.
understand the Miranda case. The Miranda case was, do you really have rights if you've not been informed of them? So Miranda didn't say you have a right to remain silent. Miranda said, you need to be informed of that right. That is these rights that you have, which is why the law here are we're telling you your rights. Miranda said that law enforcement has a requirement to inform you of certain rights when they take you into custody. Right? Your right to remain silent, your right to an attorney, they don't come from Miranda. Miranda merely said, by the way, you need to tell them beforehand. They need an informed consent before they start yammering at the mouth. When I'm not familiar with the case as to when they added the fact that the state would provide a lawyer if you couldn't afford one.
I'll see if I can find it and link it to you.
I'd be curious. Yeah. So what else is going down?
Oh, I thought somebody else was saying something.
I haven't checked the chat. Let me check the chat. Nope, nothing new in the chat.
I think Christopher wants to say something.
Go ahead.
Sure.
No, I didn't. I actually unmuted my mic. I meant to mute it, not unmute it.
I happen to talk a lot, so if anybody thinks I'm talking too much, just tell me to shut up. I won't take offense, I promise.
Oh, it's fine. It's good for all of us to hear these kinds of stuff.
I think it's very interesting that people refer to the right to remain silent. I do believe that you have a right to remain silent, just like you have a right to speak. But the Fifth Amendment does not enumerate a right to remain silent. It enumerates a right to not incriminate yourself. Now, typically, you incriminate yourself by speaking.
No. You have a right not to be a witness against yourself. Very important distinction. Amendment 5. Let's look at Amendment 5. Nor shall be compelled in any criminal case to be a witness against himself. You have a right against self-witness, not self-incrimination.
Okay.
If you don't want to admit to something just because you'd find it embarrassing, whether or not it's incriminating. All right. For example, if you're being arrested for a crime because they say you were in one place at this date and time, and somebody saw you stealing a car, and you said, no, I wasn't there. They said, well, where were you? I won't say. Why? Do you have something to hide? No, I have everything to protect. Now, maybe it's simply because you were with your girlfriend and you didn't want the embarrassment of being known that you were with your girlfriend, especially if your wife is in the room with you. You may not have simply, right? It's not a question of incrimination. It could have been as simple as you were off fishing when you were supposed to be grocery shopping. And you didn't want to tell your wife. Your wife wanted you to go to see the latest chick flick. You said you couldn't because you had to work late. And instead, you were out drinking with your buddies. Whatever reason you want, you cannot be compelled to be a witness against yourself. And the fact that you are not a witness against yourself is not evidence of guilt. Although we hear that a lot. You see it a lot in the crime dramas. If you've got nothing to hide, same thing with asking for a lawyer. Only guilty people. No, only people that have something to protect. What are you protecting? My rights.
So clearly I got the words wrong. Though I do believe you have a right to silence. You have a right to not incriminate yourself. You have all these rights that people refer to as rights, and they fall under the protection of the Ninth Amendment. I call it the redheaded stepchild of the Bill of Rights because it is sorely neglected. Nobody ever thinks about the rights that are protected by the Ninth Amendment, which nobody knows what they are. They're just rights that are reserved by the people.
They're rights that have not been enumerated in the Constitution. So you use the example of the right to remain silent. You're right. You have the right to not be a witness against yourself. You have you have the right to speak. I have the right to not speak. Not speaking is not enumerated, but it's protected by the Ninth Amendment.
Right.
You know, it's you're right, but that part of that part of the reason is we don't educate people on what a right is. I actually created a class called What is a Right? It's a 1-hour class where I go through and I define a right. And trust me, rights are not simple, not nearly as simple as almost everybody I hear talk about them. The definition, the Noah Webster definition of a right is a just claim, immunity, or privilege. Right? Just meaning it's right, it's correct, it implies justice. You can have a just immunity. You have a just claim. So, for example, we'll go back to the right to I have if I'm charged with a crime, I have a right to trial by jury. I have a right to a claim on the government putting on a trial and to compelling fellow citizens to be a jury, right? That is a just claim. I have the right to compel witnesses. That is a just claim. I have a right to I have a right to not have my freedom of speech abridged. That's a just immunity, right? A just immunity, something the government cannot do to me, or something that someone else cannot do to me. Although we tend to focus on government from a legal standpoint, your freedom of speech is not simply freedom of speech from government coercion, right? YouTube violates freedom of speech. Facebook violates freedom of speech. It's just legal for them to do it. I should say it's not a crime for them to do it. Right. So just claim, a just immunity, a just privilege. I have a right to vote. Right. I have a right to participate in the election of representatives in a republic. That means the privilege of going and voting is just, that's just the opener, right? I spend an hour talking about this. Here's the good news. I can wrap up a definition of rights in 2 sentences that is 95% of the time 100% accurate. It's a Yogi Berraism, but right. For you to legitimately exercise a right, it must not infringe on the legitimate right of another. Therefore, for a right to be legitimate, I must be capable of exercising it without infringing on the rights of another. Now,
I always like the stranded in the middle of the woods thing. If I can do it in the middle of the woods, I should be able to do it. But as soon as I have a neighbor, if it involves me taking something or having anything to do with him, then we might start having issues. So, for example, wandering onto his property and cutting down his tree. That's his tree, not mine.
Yep.
So it's a violation of his rights. But if I want to cut down the tree in my yard and he doesn't like that, well, that's too bad. It's my tree.
Correct. Right. It's back to that. All right. You can exercise it. Can you exercise the right without infringing on the rights of another? If you're cutting down your own tree, you haven't infringed on their rights. They don't have a right to look at your tree. Right. On the other hand, you can't go to them and cut down their tree because that's theirs. You're depriving them. You're infringing on their rights. The second, it deals with things like the right to education, the right to health care, because those cannot be legitimate rights because there is no way to exercise them without infringing on the rights of another. And the reason I say it covers about 95% of the situations is because technically I have a right to, I have a claim on a jury. If the government charges me, then I can infringe on your right to be at liberty by getting the government to require you to show up to serve on a jury. Right? That's that corner case where the only reason we're allowed to infringe on someone else's right is because we are protecting the right of someone else. Right? So that gets into that whole mess. Hello, Jan. You popped in here. Glad you could join us. Let me go back to the chat room, see if there's anything in there. No. Ooh, says I got 4 people on YouTube. I don't know if I've really got 4 people. Hello, YouTube. Those of you on YouTube, if you don't know, we're doing questions and answers. All you have to do is type a message into the comments. It'll pop up on my screen and we'll see if we can answer it for you. Please keep it thoughtful and ask about we're talking primarily about the Constitution. We're having a lot of fun. At least I'm having a lot of fun. What was there? Something actually, Lord, you said something before and it got me thinking and I lost track of where to come back to. Oh, the Fifth Amendment and being deprived of life, liberty, and property. Most people have no clue what is protected by the Fifth and 14th Amendments. So when they talk about depriving you of life, liberty, or property, we all know what life is, right? We live, right? When the heart stops beating, you've been deprived of life. George Floyd was deprived of his life without due process of law. Now, there are questions about how that case was handled, but you can pretty much assume that until further evidence is provided, that George Floyd was deprived of his life without due process of law. Okay. What is liberty? Liberty, by the way, I talk about liberty when I talk about rights. So if you want to find out more, actually, if you're an apprentice at the Constitution Scholars, I think that's up there now. What is a right? If not, let me know and I'll. I'm been playing around with some of the classes there, but liberty can be summarized as not being affected by an outside force except by the laws of nature, where you restrain yourself by the laws of nature, or you are restrained that is necessary for society. Right? Let me try that again. Liberty is freedom from external influence. Natural liberty is that freedom, you restrain that freedom based on natural law. In other words, you don't hurt people, you don't take their stuff. Civil liberty is natural liberty restrained only as is necessary for the security and efficacy of society. Right?
I like to point to speed limits for civil liberty.
Yes. Right. Civil liberty is, there's no natural law that says how fast you can drive. But so that we can coexist as a society on the highways, we set speed limits. We drive on the right side of the road here in America. Or as one person I heard described, in America, we drive on the right hand of the road. In Britain, they drive on the left hand of the road. In India, they drive in the shade, which makes driving in India a lot of fun. So liberty is your ability to go about without unnecessary external influence. And in fact, Noah Webster says that any civil law, any infringement on civil liberty, not necessary for the safety and security of society, is tyranny. So when government comes and says, you cannot go about your business unless you wear a mask, unless you get a vaccine, unless you have a permit, unless you get a license from us, that is all depriving you of your liberty without due process of law. Property. I did an article on it. If you go to founders.org, James Madison did a very nice essay on property. Basically, property is not only what you own, it's what you have an interest in. So, he said that you not only have a right to property, you have a property in your rights. So when you're a business owner and government says you have to shut down because you're not essential, they are depriving you of your property. When government says you can't do, you can't do that in your property because we consider that a wetland and therefore our waters of the United States, they've deprived you of property. Oh, by the way, the governor of, Ohio? There's one governor, an attorney general that's trying to get Google declared a public utility. That is a takings. They are taking property without just compensation. Right? Even things like your ability to work. You have a property in your ability to work. So when government says you must join a union to exercise your ability to work, they've deprived you of the property you have in your ability to do work. Now go back to the Fifth Amendment. You shall not be deprived of life, liberty, or property without this thing we talked about before called due process, a process designed to protect your rights. When I come out and I talk about knowing your rights, we're going to be spending a lot of time with the due process clause in the 5th and 14th Amendment, because that is where the majority of the rights of the people were trampled by states and cities, primarily, not exclusively, but primarily states and cities in 2020. Now in 2021, we've got more, but that's our burden to bear.
So I just had a thought about just compensation. Now, the question is who determines what is just compensation? And I just had a thought, well, whenever you're, bargaining with somebody, it's you two. And when you two come to a conclusion about the price, then that's when just compensation is met. So say, the government comes up to you, say, I want your house. Here's money. Can you say, well, that's not enough? And you just keep saying that,
Absolutely.
would that work? Like, I think that would work. I mean, that's how normal transactions work when it comes to bartering.
Well, yes. So yes and no. The problem you have is government is by definition force, right? So, and government, and what they'll do is, government will say, well, this is what we'll pay. And you say, no, that's not enough. Well, we'll just take it. And that's all we'll pay you, because that's what we think is just compensation. Sorry, government, a one-sided justice is not justice. In general, just compensation is considered the fair market value for whatever the item is. Now, we often talk about real estate. Who was it? It was in Connecticut. I'm drawing a blank on the lady's name. She went all the way to the Supreme Court to have the city of Loudoun, Connecticut, steal her land to give it to a corporation. And they did a movie about it. I can't remember the name. I can't remember. It'll come to me later. Part of the problem was the town condemned her property to drive its value down. See, all of her neighbors sold. She wouldn't sell. So the city comes in and says, oh, it's a blighted property. We're going to condemn the property to drop its property value so that we can take the property. She says, no, that's not its fair market value. And it went all the way to the Supreme Court. And surprise, surprise, the Supreme Court says, no, Loudoun, Connecticut can take it and pay whatever they want for it, even though it wasn't for public use. Remember the pesky little Fifth Amendment? Where is it? Nor shall private property be taken for public use without just compensation. What happened in Loudoun, Connecticut was not a takings. It was a deprivation of property. She took it. They took the property to provide it to a private company, not public use. Supreme Court says, no, they'll get taxes for that. It'll now be productive. They'll get more taxes. That's the public use. They're lying through their teeth. I have very little respect for most of the justices, because even the one or two things from Amy Coney Barrett have been questionable. She's come to some questionable decisions. Kavanaugh, Gorsuch has been pretty good. Thomas, I think, has been pretty good, unless law enforcement's involved. But my biggest issue with all of them, going back to what Sean and I were talking about before, they based their opinion on their not on the actual Constitution of the United States that they swore an oath to. They put their hand on the Bible. They swore affirmed they would support the Constitution of the United States. Yet they still have a job. Because to me, violating your oath of office is bad behavior. And that's how long federal judges serve, during their good behavior. So therefore, bad behavior should be gone. But what are you going to do? But it's part of, that's right, part of it's the education. So anyone else? It's a little past the top of the hour. We still got a little bit of time. Anybody else got an interesting question?
I don't really have a question, but I do have a statement.
Okay.
One of my favorite episodes that you ever made was it's called "What is the Price of Liberty?" And it was when you did Patrick Henry's "Give Me Liberty or Give Me Death" speech.
Yep.
I've listened to that so many times, and I show people all the time. I love that speech so much, and I don't know. I was just one of a few of the other Constitution podcasts that I've listened to in the past. They've done like the Constitution front to back, and like so they go through each line of the Constitution. So all legislative power shall be vested in one Congress of the United States. And then they say the word all means, funnily enough, all legislative power. This is what legislative power is. One Congress is Congress. There's only one Congress. And, then he moves on to the next line. I don't remember what the next line is, but, and then goes all the way through the Constitution, all 27 amendments. And I was just wondering if you would be interested in doing something like that, if you have time. I know you're really busy with your new radio talk thing too. So
that actually is the book. The Constitution Study book is every Declaration of Independence, Constitution, every clause. And I say the exact same thing. All legislative power means all lawmaking power is vested in Congress. So when Congress turns around and says, we're just going to write this kind of framework of a law and we're going to let an executive agency do it, no, that's a violation of the Constitution, because Congress was not delegated the authority to delegate their power. So if you want, that is, and I've toyed with the idea of doing that as an audiobook. I've been playing with a couple of things for audiobooks. I did a primary recording of Read the Constitution in 30 Days that I've recorded for an audiobook. I haven't finished it. There's actually a fair amount of work to doing one of these as a decent audiobook.
Well, to be fair, I really wanted to read the book, but I don't read very fast, so I don't really read anything. Everything that I read is an audiobook. So no offense, but that's why I had no idea that you'd already done it.
Yeah, that is the book. Like I said, I've considered doing it as an audiobook. That, for those of you who haven't seen it, I mean, it's a good sized book. It's 450 some odd pages. There's a lot in there. That would take me quite a bit of time to record, much less edit and put in backgrounds and all that stuff. There's a lot there. The advantage, even if you can't sit down and read it cover to cover, one of the things that's helpful about it is to find a piece and read through it. Whether, like we've been talking about, the Fifth Amendment or the Supremacy Clause, and there's a couple of them I go into. I like picking on the Supreme Court's third party doctrine and stupid stuff like that. So yeah,
I just realized something that I had wanted to talk to you, but I missed, the last 6 seconds or something like that. I recently found out that Wyoming has banned the ability to form private militias. And my question was, how could you come to the conclusion to ban an integral part, an institution enshrined in the Constitution? Like how can you even come up with the wording to be able to ban something like that?
Well, so there's a couple things. I'm not familiar with Wyoming law, but let's face it. Who is it? I think Ron Paul had a sign on it, had a plaque on his desk. It says, "Don't be corrupt. The government doesn't like the competition." Right? Government doesn't like competition, and government is force. So understand. You got to understand a couple things. Not to mention, so I want to make the point that Wyoming's law is not nonsensical because of the Constitution. It's nonsensical because it's trying to ban something that can't be banned. So let me get there. Right. So let's start out with most governments don't like the idea that they are not the big kid on the block, that there's someone can stand up to them. They don't like that. So when they look at it and say, and also understand that the term militia it's gotten a bad reputation from some people who've really done stupid things in the name of militia, right? So you have a lot of anarchists, borderline insurrectionists that get together, get a bunch of guns, call themselves a militia. So we've been shown this idea that the militia is a bunch of crazy people out in the woods with guns. And the people in Wyoming said, and the government in Wyoming said, we don't want crazy people out there with guns, so we're going to ban a private militia. Well, here's the problem. The definition of militia is an armed populace. You cannot ban a militia because as long as you have people, the only way you ban a private militia, a quote unquote private militia, is if you ban all firearms. As long as you have people with arms, you have a militia.
See, I figured just get together with a bunch of people who like guns and like to do tactical training, and then just hang out together and shoot targets and do tactical training. But we're not a militia. We're just a bunch of friends out shooting guns.
Yeah, what they're really talking about is formal organization of a militia. And it is up to the state to appoint officers for the militia, but the members of the militia are everybody. For example, now my cousin, I don't know how to put this. So we would have cookouts at my cousin's place. My cousin has a place out in the hinterlands of upstate New York. And well, let's say that whenever we had a family cookout at 3:08 in the afternoon, we all headed he has two sons that have neighboring property. One of them has basically a shooting range. And so at 3:08 in the afternoon, we all wandered over to the shooting range, and you would show up with whatever guns you were willing to share. And we'd set up folding tables, and you just show up, you'd put out the guns, you'd put out the ammo, and you took your turns, pick whatever you want, shoot whatever you want. We had targets set up. We used Tenorite. We had so much fun. If people who were not familiar with a firearm, there was always someone there to help. We've had everything from children to senior citizens showing up, try a gun, try something. I've shot everything. I shot a 50 cal. I shot what was the other one we shot? A 600 nitro. I mean, there was one guy, he's bringing out crazy stuff. We would have fun blowing stuff up. We had beater cars out there with Tenorite targets in them. I mean, we just had a blast. Some might call us a militia. We were just a bunch of guys out in the backwoods having a lot of fun with guns. By the way, no one ever got hurt. No one was ever put in danger. We had a firing line. Those of us who are most familiar with firearms, we always enforced the gun safety rules. We did, right? We had a grand old time. Guess what, man? If something went down while we were hanging out, we were a militia. There you go. We had the arms, we had the willpower. Go for it. We don't care. So yeah, it's but it's part of it is militia's gotten a bad name what's interesting is there are some great quotes. Next week, Monday and Tuesday, I'm doing a 2-part radio program titled Raising a Nation of Militias. I'm sorry, Raising a Nation of Minutemen. And I went through some of the quotes I have of the founding fathers around militias and owning firearms. And
I've probably read every single one of them. It's my favorite topic.
oh, it is their right and duty to be at all times armed. Benjamin Franklin, those who beat their swords into plowshares are likely to plow for the people who still have swords.
There was one, I
that's a
think it
good
was
one.
Patrick Henry. I think it was Patrick Henry said something about not only should everybody be trained in the use of arms, but they should start young.
Actually, I think it was. I know the one I think I know the one you're talking about.
I'm loose to accredit it to anybody. I just know I've read the quote, and I was like, I love it. That's amazing.
Richard Henry Lee said, to preserve liberty is essential that the whole body of people always possess arms and be taught alike, especially when young, how to use them. That was from the Anti-Federalist Papers, Letters to a Federal Farmer. I believe it was Anti-Federalist Papers. So yeah, I mean, there's to me that is politicians trying to getting pressure because some yahoos called themselves a militia, gave it a bad name, and the government's just trying to cover their backside.
They're probably feds making us look bad.
Yeah. I still remember, who is it? The Adams son. I can't remember his name. John Adams' son. He was a president of the United States. I'm drawing a blank on his name. As a young boy, as he was like 14 years old, doing musket drills with the Massachusetts militia. I grew up around firearms. I mean, there were firearms in the house from as young as I can remember. I was taught to respect them. I was taught how to handle them properly. Everyone. One of the stories I covered is Colorado is set up a new gun storage law. And I'm like, the only reason you need a gun storage law is because people aren't teaching their children how to handle guns. We didn't need a gun storage law in my father's house because I was going to say, we didn't need a gun storage law in my father's house because A, he told me how to handle them. B, I know what would happen to me if I misused them. and I was much more afraid of what my father would do if I touched the guns I wasn't supposed to than anybody else. Forget what the government was going to do. I was afraid of what my father was going to do to me. So,
Derp. Sorry, my brother was doing something funny. Anyways, I got a question myself. So I remember you made a video a while back addressing the definition of militia, and it pretty much summed up as the individuals, the private citizenry, and then the National Guard, essentially. And I mean that right there kind of defends your point you made earlier about you can't ban the militia.
Yeah,
by the definition alone.
Yeah.
So in Wyoming, there's the organized militia, which is classified as the National Guard. And then there's the unorganized militia, which is every able person from the ages, I think it's between the ages of 17 and 75 years of age are the unorganized militia.
Yeah.
But I mean, that's like drafting or something. The problem with that is that because all of these people are technically the militia, how can you ban militia? That's why it doesn't make any sense to me.
You're expecting a government to do something that makes sense. There's your first problem.
Oh, you got me.
And Tunler, the definition of militia is an armed populace. The federal law also defines two militias. The National Guard and the Reserve are the organized militia. The National Guard is the organized militia. The every armed, able-bodied male from 18 to 45, every woman who served in the National Guard, and every male who has served in the armed services up to age 65, I think, are all considered the unorganized militia. And the general idea, the reason we have militias are one, we have an organized militia so that we don't have to keep a standing army. But here's
Which
the
we
part I
have.
like. Yes, we effectively have a standing army, and there's issues. But here's the part that I want you to think about, because I get this question all the time. Well, what are you going to do? They've got all the guns. They don't have all the guns. I did a little research. If you include the military, the National Guard, and all the reserves, and the Coast Guard, the federal government can lay its hands on about 2 million armed people between all the military, all the armed forces, all the organized militias. 2 million people. There are over 100 million armed citizens in the United States. The best estimates is over 100 million. Now, during the Revolutionary War, roughly 1/3 of the colonists were for independence. Roughly 1/3 of the colonists wanted to remain British subjects, and 1/3 didn't care one way or the other. However, the interesting number is only 3%, approximately, of the colonists actually fought in the war, actually took up arms. 3%. If there is 100 million gun owners in America and only 3% of them are willing to take up arms in defense of their rights, that's 3 million to 2 million. Now, granted, they've got bigger guns than we do, right? Because they kind of keep us away from the fighters and the bombers and all
The
that.
fun stuff.
Yeah. But the interesting thing is, how long have we been in Afghanistan?
What's crazy about that is you could learn a lot from those guys watching some of those Middle Eastern videos out there of how to deal with a professional army, I guess you could say.
Mm-hmm.
Like I a couple of years ago, I used to watch those videos because I thought they were kind of interesting watching the conflict. 'Cause I don't know. I thought stuff looked cool. Anyways, it's not it's not going to be easy, especially with us, because we're far better trained than those guys are. Far better trained.
I would
the
actually
interesting part
argue
is-
that the Minutemen were far better trained and organized than really any of us, short of having some sort of military background. I mean, most of the people I know at best go out and plink every once in a while. They don't actually do any combat sequencing. They don't learn how to clear buildings. They don't learn how to work as a team and form in groups or anything like that. And the police, the military, I mean, ATF, all these people, they train on how to do that. So, I mean, that puts us at a disadvantage. And then there's also the fact that they get hand grenades, and that really bothers me because, if hypothetically, if we were to ever, we the people, were to ever get into armed conflict with the government, they have hand grenades and we don't have them, which means they're going to use the weapons of our defense in offense against us.
That's why the Second Amendment says the right of the people to keep and bear arms, which is defined as basically it's a weapon you can pick up in your hand to strike or assault someone. So
I don't remember where I found this definition, but the definition of arms is anything a man can pick up to impose his wrath upon another, or armor of defense.
Yeah.
Arms.
No, Webster refers to it as arms for or weapons for offense and armor for defense, but I forget where it was. I think it was it Merriam-Webster? One of the newer dictionaries, I think. I saw the definition of something you can take in hand to strike or assault someone. Right. So, but the interesting point is, you have to remember, when we fought the revolution, we were still undergunned. Now, granted,
I do know that.
Right? And we were certainly undermanned. But what did we do? We fought different. we in other words, we did exactly what the people in Afghanistan did against the Soviet Union and against us, and the people in Iraq did. They said, we're not going to get out and stand up and line up and do 4-man drills. We're going to play sneaky. We're going to hide. We're going to be tricky. We're going to. It's an interesting discussion. The point I try to make is we're not as helpless as we've been led to believe. But the other point I need to make is if we get into a shooting war against our government, it's because we have failed.
I agree.
All right, that we have this tremendous opportunity. We've had it for decades to control our government at the ballot box. If we have to go to the battlefield, it's because we as a people have failed. And if I may take a word from Mr. Washington, where's this quote? I want to get his quote.
While you're looking for that, I was actually talking about how we're better trained than the people out in the Middle East. That's what I meant.
Mm-hmm.
Oh, my bad.
Yeah. What I do understand what you mean though about people not actually training well. Just simply shooting a target isn't good enough. You got
and I agree. The Second Amendment that the point of the Second Amendment that I always point to people is it says a well-regulated militia. That means well-disciplined, organized, ready to go at a moment's notice. Right. This is all the things that Minutemen were that we are not today. If UN soldiers were driving down the interstate right now to come confiscate guns from Casper, Wyoming, fun fact, I live in Casper, Wyoming, would people be organized enough to stop them at the interstate and say, you will not enter my town? This is my town. You're not coming in.
I have a better example. I have a more recent example. You know the McCloskeys in St. Louis?
Yes, sir.
Right. When that video first hit of them defending themselves, you know what I noticed? They didn't do a very good job of it. Yes, they had guns, but if you notice, they were not behind cover. They did not have clear. They did not have clear shooting lanes. They did not have clear sight lines. In fact, at one point, I heard an interview with a husband. He was actually in the doorway. His wife, he was on the porch, I think. His wife stepped out in front of him. He's there with an AR, right? And his wife stepped out in front of him. Yeah, right. The regulated militia is simply being, how do you properly, even just, you don't even need to get into formula right now. How do you properly defend yourself against a mob? Forget the UN troops. That's like that's an advanced class. How about the mob comes for you? How do you defend yourself without putting your own people in unnecessary danger?
Well, I was just using it as an example.
Oh yeah,
I use the example of home invasions all the time.
Yeah,
because if somebody breaks into your house, do you know a good defensible location where you can? Does your family know that they should stack behind you so that you don't have to worry about shooting through the wall and accidentally shooting them? These are all things that are important in home defense.
Or how about this one? How about a keyword? How about a word or phrase that when you use it, everyone shuts up and does exactly what you said because you're the one there to defend them? Or if a member of the family says it, it's an instant, something is wrong, and we move. We something is wrong. We decide and we move. We do something. There's a word in our family. If that gets said, no matter where we are, no matter what we're doing, we all stop, focus, what's going on around us, because now is a chance to move. And since I'm the one that's done the most work in this, they follow my lead. Right? We've sat down and discussed this. And I drove when my daughter was a teenager, I drove her crazy because every time we went out to dinner, anytime we ate out, at some point I would say, where are the exits? Have you, all right? It's like, Dad, trust me, where are the exits? And you know what she always forgot? The kitchen. I said, there's always a way out through the kitchen. I said, if something happens, if I see something, if you see something and it's time to move, you got to know where you're going to move to. Be aware of that. We don't do that. Some people think I'm crazy for doing that, but we're a little past the bottom of the hour. I want to close on a quote from George Washington from his first inaugural address. And since the preservation of the sacred fire of liberty and the destiny of the Republican model of government are justly considered as deeply, perhaps as finally staked on the experiment entrusted to the hands of the American people. This has been entrusted into our hands. It's up to us to do something. We can start with reading and studying. We can please start with sharing these messages, the videos. This video will be up probably tomorrow afternoon. All my videos are up on YouTube. They're up on Rumble. I am, point people to the website. Everything on the Constitution Study is absolutely free for people to use, for people to share. I did put up a donation bin for the tour to help offset some of the costs. Most of the people, I'm still tracking some of the stuff, but most of the people have been very kind about providing hotel rooms while I'm there. I appreciate that greatly. This is all about getting this word out that if we want liberty, if we want to protect a truly representative republic, then it's in our hands and it's up for us to do something. And I thank everybody that comes up and shows up to these. We have a great time. And by all means, invite friends and family. And I'll probably see you in a couple of weeks. Night, everyone.